The next matter to come before the court is Pignatelli versus Township of Bath. Good morning, everyone.
Good morning.
Each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes, and we're ready to proceed anytime you like. And just let me know if you want to reserve some time.
Good morning. May it please the court, I would like to reserve 3 minutes from my presentation. My name is Lee Chilcote, and I represent the appellant in this case. To begin, Ohio Revised Code 519.14c, conditional use provisions are allowed by townships in their zoning resolutions. In doing so, the legislature is recognizing that the compatibility of uses is circumscribed by the surrounding circumstances. However, BZA will, while it will have a right to deny or grant requests, the BZA's decision is not unlimited. In Gersony versus Richfield,
Excuse me, its discretion is not unlimited.
it's discretion. I'm not sure what I said there. Yes, the discretion is not unlimited. In Gersony versus Richfield, the BZA specifically held that they must grant conditional use permits, quote, in accordance with legislatively prescribed standards and conditions, and may not act outside its discretion, quote, independent of the zoning resolution. So that's Gersony. This court clearly enunciated in Smith versus Richfield that orders of the township BZAs, quote, are constitutionally permissible so long as the BZA applies and interprets existing law and does not promulgate new law. As you well know, in Smith, the Richfield Township imposed several conditions on a property owner that were nowhere found in the Richfield zoning resolution. The court stated a board is not free to impose its will upon an applicant because it would usurp the authority of the legislative body that created it. The court went on to state that the conditions imposed were not part of the existing resolution. The board was creating new zoning law and found specifically that BZA's action went beyond the scope of its constitutional authority because the board was not applying existing zoning law, and held, quote, that the right to impose conditions can only arise when those specific conditions are included in the zoning resolution. As is the case in Smith, the case here is that there are several provisions that are nowhere found in the Bath zoning resolution. Those conditions take the form of perpetual, affirmative, and negative covenants that are to be contained in a recorded instrument that will, if allowed, cause the covenants to run with the land in perpetuity. Included in the permit are permanent negative covenants against rental, non-owner occupancy, and lot splitting, and permanent affirmative covenants requiring owner occupancy, and that the Bath Township inspector be informed as to living arrangements for both the main house and the guest house. No rental or non-owner occupancy of the main house is allowed for Pignatelli or, in fact, any future owner. No such prohibitions are contemplated or contained in the zoning resolution. Similarly, an absolute and permanent prohibition against lot split is required. No such prohibition is contained in the zoning resolution. In fact, lot splits are governed by the Summit County regulations. Compounding all of this is the fact that there is a requirement that the owner place involuntarily covenants in an instrument to be publicly recorded that thereafter will run with the land.
Excuse me. Is there any mechanism for, at some time, removing those covenants once they're placed in the deed?
And not spoken to in the permit at all. Not spoken to.
As a
And
matter of,
presumably not, because they are listed as deed restrictions with the implication that they will be perpetual and not removed.
thank you.
But it's not entirely clear. Let's look at the reality of this situation. The Bath Township trustees enacted a zoning resolution that expressly allows a guest house. And it says, persons employed on the premises or for temporary use of guests of occupants of the principal residence. It's logical that they would do this because the only difference here from what you would have in your home is that you have a separate structure. And surely persons can have guests in their home, can have employees in their home. And what's allowed by the zoning resolution is the same use in a separate structure. Nothing in the zoning resolution prohibits rental or non-owner occupancy of the main house or lot splitting, doesn't prohibit lot splitting, nor are there reports required, nor are there required recorded covenants at all. Apparently, the BZA is opposed to guest houses and wants the legislation to be narrowed. Unfortunately, the BZA doesn't have that power. The BZA may not deny conditional use zoning certificates because if it's not in the legislation. The case for that is the Gillespie versus Stowe case, which, I'm sorry, I'm mistaken there. Bear with me here. It's simply outside the legislative authority, and the case is Gillespie versus Stowe. The other point I would make quickly is that the Bath Township ordinance specifically states that conditions on permits may exist only where necessary to safeguard health, safety, or welfare of the community. Nothing in these covenants safeguards the community. These covenants punish the Pignatellis. The BZA attempts to justify the covenant requirements as necessary for notice enforcement, but I'm sure, as the court knows, the notice and enforcement provisions are provided elsewhere in Bath Township regulations. To understand the impact of this, ask yourselves, what does this mean to the Pignatellis? Could the Pignatellis ever sell their property if they're the property in Bath Township that has these recorded restrictions against their deed? Would the recording of the covenants entitle Bath to proceed in enforcement through forfeiture proceedings, thereby taking the property from the Pignatellis? As the Supreme Court in the case of Sanders versus Clark County indicated, resolutions are ordinarily construed in favor of the property owner. Restrictions on the use of real property must be strictly construed, and the scope of the restrictions cannot be extended to include limitations not clearly provided. Going a little bit farther into the case of Froelich, which is a foundational zoning case in Ohio. The words are something to this effect: zoning is a police power derived from statute. The exercise of zoning must promote the health, morals, peace, welfare of the community. Zoning regulations must be reasonable and rationally relate to the purpose. And importantly, they must not single out or unduly oppress certain individuals or unnecessarily interfere with private rights. To really get at the question of the legitimacy of these conditions, we should ask the question, what would be the consequences if none of these covenants were actually adopted by the Board of Zoning Appeals? Well, if you look at the zoning resolution, the use of the guest house would still be limited to employees of, or for the temporary use of guests of the occupants of the main house, as expressly provided in the zoning resolution. No covenants would be of record, but Bath still could enforce its regulations as expressly provided in the housing and building codes of Bath. And importantly, the owner could apply for subdivision, importantly, like all property owners in Bath, the owner could exercise its right as an owner and use its property for a home without burdensome restrictions. That's all as provided in the Ohio Constitution. I do want to just take a moment and talk about constitutional considerations briefly. The rights related to property to acquire, use, and enjoy and dispose of property are among the most revered in law and traditions. The right of private property is an original and fundamental right and exists anterior to government itself. Those, of course, are not my words. Those are the words of the Supreme Court in the case of the City of Norwood versus Horning in 2006, which leads to this conclusion. Imposing those covenants violates substantive due process because the covenants are not rationally related to the legitimate exercise of police power, i.e. the health, safety, welfare. They rather relate to the general purpose of the resolution, which is to maintain the overall character. And that's the specific holding in Gillespie versus Stowe and also the Gerson case, which this court knows well. Secondly, the means adopted must be suitable to the ends in view and must be impartial in operation and not unduly oppressive to the individuals. I've already cited that language that comes from the Froelich case. Last, we would suggest that if the resolution as approved by the Court of Common Pleas were allowed to operate to permit the BC unlimited discretion to adopt conditions, we would argue that the zoning resolution itself violates separation of powers, represents an unlawful delegation of authority, and would be questioned to its own validity. We don't think that was the
You're just not ready to
intent.
start your 3 minutes. You can continue to argue if you want, or you can reserve those minutes.
No, I'll just conclude by saying this is an error of law, this is an abuse of discretion, it violates Ohio constitutional principles. Thank you.
Thank you.
May it please the court, I'm Bob Constand. I'm representing the Bath Township Board of Zoning Appeals before you today. I think I need to bring to your attention, before we get into the law and what took place in this case, a few things about this zoning district in Bath Township. This is an R2 single-family zoning district. Predominantly, Bath is R2. They don't have a lot of commercial development. They don't want commercial development. R2 says that you need a minimum of 2.5 acres for each single-family home. What the trust has presented before you today was to change, through a conditional use application, the single-family use designation within that zoning district by means of the guest house. The guest house was going to allow another family or group of people to live in the house or on the property.
The condition that they be employees.
Or temporary guests.
Right, or just, yeah.
And that's how Bath allows that under the conditional use.
But that doesn't violate the acreage requirement.
No, not at all. My point being, Your Honor, that if there were two separate houses where the occupants didn't meet either temporary guests or employees, then you would need a lot split.
But that's not an issue here.
It is not. What is an issue, in my view, are basically two things. First of all, I think there's an issue of fact that the trust at the hearing before the Bath BZA conceded to the deed restrictions and said that they would be willing to abide by them. The Court of Common
Does that
Pleas.
mean that they can't change their mind?
I take that as a stipulation at a hearing. Once they've stipulated, they can't change their mind.
Well, okay, so let's say that is true, that they have stipulated or agreed to it or whatever. If it's illegal, if it's something that is not enforceable, if it's without side of the scope or the power of the BZA, does it really matter if they conceded or stipulated to it?
Well, I think the argument, Your Honor, is that if the BZA imposes deed restrictions and they don't have authority to do that, then they won't be lawful. I think if a party voluntarily stipulates to the deed restrictions, then that argument isn't applicable where they voluntarily agreed to it.
Well, I understand what the argument is, but I guess what I'm saying is, doesn't it still go back to whether the BZA had that authority to impose that? Let's say the BZA just wanted to change it from R2 to commercial, like you said, and say, well, as long as you agree to it.
And that, in fact, is done. I understand your point.
I don't think the trustees would be too pleased with that, would they?
No, of course not.
Right. So that's what I'm trying to get at, that's the reason.
I did mention.
Sometimes my questions sound kind of silly to
No,
me,
I understand completely.
But I have to try to figure them out.
No, and I anticipated that, and in my brief I mentioned the doctrine of invited error. And in that basically would be applicable in this case, that now the appellant, the trust, cannot shy away from that because they conceded to a trial court.
And I understand your argument, I'm just trying to wrap my head around all this, because let's say that it's a criminal case and the defendant comes in and pleads to an offense and is punishable up to 1 year in prison.
Mm-hmm.
And he says, you know what, I'll do 10, I don't care. And the judge sentenced him to 10. And then he appeals, even if he agreed to it, we can't enforce a 10-year sentence against him, can we?
No, because there's specific statutes that limit the duration of sentences. I'm not a criminal expert and don't pretend to be, but I understand what your point is
Right.
in terms of what's lawful. I will point out that Section 802-1C of the Bath zoning resolution, and this was mentioned by counsel for the appellant, and if I may quote, "The Board of Zoning Appeals shall have the power to impose additional conditions where it deems it necessary to safeguard the health, safety, and welfare of the community. These types of conditions may include, but are not necessarily limited to, the following." If you go to C, future development of the site may be or partially restricted.
Yeah, but it doesn't say in the deed.
No, but all the deed is just the means. And the whole argument of Bath Township, Your Honor, is that none of the specific conditions have been objected to. It's just the means of enforcement to protect the township, because this is real estate.
Is the township requiring everybody to have all of this in their deeds?
Only where there's a conditional use for a guest house. We've used that before. Bath Township probably only has 2 or 3 guest houses within the township that I'm aware of. It is frowned upon because it does violate the single-family zoning.
Let me ask you a question. You're talking about it has to be owner-occupied. It's a trust that owns the property, so who's the owner?
Oh, I would assume it would be the trustee or the beneficiaries under the trust. And getting back to your point, Judge Whitmore, that you asked earlier, these deed restrictions are only applicable if the guest house is going to be occupied. So if the trust would decide to abandon the guest house and operate as any other house in an R2 district, then all of these deed restrictions aren't applicable, because this is only applicable to use that other house as a guest house. So we're not interfering with his rights. He has more rights than his neighbors do because the township went ahead and gave him the right to use that guest house. But they added conditions to it. And the conditions are already specified in the Bath Township zoning
And
resolution.
they've been specified for some time, correct?
That's correct,
So why all of a sudden do we have to put them in the deed?
for purposes of enforcement.
Well, they could have been enforced in the past.
It's a lot easier, Your Honor, rather than to go into court and seek an injunction, is to just file for breach of contract on the deed restrictions. There's no forfeiture or anything else. It's a civil action. We can't foreclose on the property. All we can do is, if there's a violation of the deed restrictions, we come into common pleas court, we ask the court to enforce those deed restrictions, and that would be a trial. There's no forfeiture, nothing else. If the court finds that the deed restrictions weren't being followed, they can order. If they find that the deed restrictions were being followed. Our concern is this, and the common pleas court, I thought, in its opinion, was very eloquent on this fact, that we're talking about real estate and improving real estate that will be around much longer than any of us will be. And how do you put third parties on notice of the deed restrictions? You can put that property up for sale, and if they have a guest house and they're permitted to use it, that property will sell very fast because basically you can put two families on there if they're related or employees. A purchaser is going to jump on a property like that because it just makes the property more valuable. But if we don't have deed restrictions, how do they know?
Well, they can do a check.
How?
The potential purchasers can look at the zoning. Their real estate agent can answer the questions for
But
them.
that's very rarely ever done.
Aren't they put on notice anyway? Anybody that buys has to be subject to zoning.
They're subject to zoning, but they're not subject to the specific, unless they look up this case, what the issue was.
And I guess what my other question would be, how is this any different than any other case? Is the township advocating deed restrictions on all the cases that come before the Board of Zoning Appeal? Because we could use this on every case, couldn't we?
No, we couldn't, Your Honor, with all due respect.
No, that's
This is
fine.
a conditional use case. Most of the cases that go before the Board of Zoning Appeals, including the Smith case in Richfield, was for a variance of the zoning code. And a variance is where there's no condition to allow it.
Well, then let me rephrase my question. Couldn't this be used in every conditional use case?
Yes.
And so then, in order to get a conditional use approved in Bath Township, now the property owner is going to have to submit to deed restrictions.
Right, that basically are just going to outline what the approval was and make it of record. It's not imposing anything else. The deed restrictions are only a means of enforcement. We're not adding any additional conditions or restrictions that aren't already in the zoning resolution.
But it has a completely different impact on the property owner's rights.
Yeah, it makes them follow what they've asked for. You're exactly right, and that's our intent. That if they want to use that guest house in perpetuity, then we're outlining how they can use it, and we put all third parties on notice on how it's been approved. That's exactly correct. So we've already discussed the issue of whether or not the trust conceded, and I would submit that for your consideration. I will note that it wasn't noted as an assignment of error. It was a question of fact. The court knows well what your discretion is in terms of questions of fact. Getting back then to the use, or the employment by the township of the deed restrictions, I think we've discussed that. The argument of the township is that this is not an additional condition. All of the specific conditions have been agreed to and were not objected to. The rentals, the splitting the property, the use by the family. The only issue is the means of enforcement. And the means.
And again, let me just go back to this. I want to make sure. So if there's a conditional use issue, then in order to get permission from the BZA, then it's going to have to be you agree to deed restrictions.
We would have the discretion. I would urge the BZA. I was the one at the BZA that suggested the deed restrictions because it was a long-term use. They were going to completely rebuild a building and make a house out of it, a residential structure, and I felt that it was necessary. If there's a conditional use that's going to be short-term, an example would be, we had the Holiday Inn in Montrose come in one day to use their parking lot for an outdoor concert. And that was temporary. That was a one-day event. That conditional use was granted. I think the township BZA needs to have some discretion and have the right to use deed restrictions as a means of enforcement. And that's all it is. It's not expanding its powers or doing anything else. All we're asking the appellant to do is live by what they agreed. Nothing more. I have nothing further unless any of you.
I think you're off the hook.
Thank you. Thank you for your consideration.
Thank you, counsel. And you're on the hook now.
A few points, Your Honors. The trust did not concede the deed restriction. If you read the record carefully, there was initial indication by Mr. Pignatelli that he might go along, but later in the very proceedings, he objected to it when he realized what was happening to him. So that's a matter of fact, if you just looked at the record. Secondly, if the BZA does not have the authority, then it does not matter whether it's a concession. If it's outside of its authority, there's a constitutional problem here, and you can't contract for the zoning or agree to the zoning or agree to the stipulation just because he's conceded it. The doctrine of invited error, which is in essence one of the same as his argument, is the same point. Doctrine of invited error does not apply if it's illegal or unconstitutional, and I think we've cited authority to that in our brief, as a matter of fact, in the reply brief.
Well, counsel, another argument could be made that the BZA was trying to help you instead of just completely denying your request. They suggested these deed restrictions so they could in fact approve.
I understand that, but the idea of the guest house, as I said earlier, is that this is a use that would be allowed in your own home. The fact that it's in a separate building with the appropriate restrictions seems to be adequately protective of the municipality. If you compare that to what is happening to the property owner here, the impact on the property rights is way out of line. You suggest that it's helpful, but it's not helpful to have deed restrictions when they're not provided for in the zoning resolution. It will affect the sale of property. Every realtor that looks at this property is going to get a title report that shows those restrictions. There's nothing in the resolution that says these are not permanent. The argument that the restrictions do not apply when they're of record perpetually and run with the land, at some point, because the use of the guest house changes. If we turn the guest house into a shed, therefore the deed restrictions are void, that permit doesn't say that, and his approach to this doesn't suggest that. The final point I would make, Your Honor, is that this represents a trampling on property rights. Anyone looking at this situation is going to say that this affects the sale of the property, affects the value of the property, and if just by placing those restrictions on record, is it our role, is it the property owner's role to make the job of the government easier, as suggested by Mr. Constant, or is the job of government to put reasonable conditions that both protect the property owner and protect the township? And I would argue the latter is what the law says.
Thank you, counsel. Thank you both for your presentations to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both of you. as well as you can look on our website and Supreme Court website.